Dean of the Law Faculty, Professor Govinji, dear delegates, dear colleagues, thank you very much for being here. Thank you, Professor Govinji, for the very, very kind introduction. I'm grateful to the Nelson Mandela University for the invitation to deliver this keynote address to the Law and Development Research Network Conference. I am very sorry that I was not able to deliver this keynote address as planned. My intention had fully been that we would be able to have a very interactive discussion afterwards, but nonetheless, I'm still very happy that I'm at least able to deliver this keynote address and that it will be available to you. The title of the address, The Potential for Environmental Use Cogens, is, I think, directly related to actually the theme of the conference, beyond the crisis, challenges and opportunities for law and development. And I wonder if it shouldn't be beyond the crises, because there are so many crises. But if we think about the environmental crises that we face, whether in the form of climate change, biodiversity depletion, harm to the environment, hazardous waste, all of these, I think, are in urgent need of attention, of our attention. And it also seems to me that any solution to these environmental crises will require law, and in particular, at least from my perspective, will require international law to play a central role. At the same time, there are serious challenges to the ability of international law to play a meaningful role in addressing the environmental challenges that are facing us. Just 2 or 3 weeks ago, I had the honor of delivering another keynote address to the Asser Institute Conference on Solidarity and Regional and International Law. And at that conference, I suggested that international law was incapable of addressing common problems because while I believe that it and many international lawyers often play lip service to solidarity, solidarity in the lexicon of international law was really nothing more than a catchphrase in a system where consent and sovereignty remain king, and where the only real constraints on states is the ability to bargain. In today's keynote, I wish to focus on a particular aspect of this theme. Also, I wish to take a slightly more positive perspective. And by the way, there is really no contradiction between the posture that I adopt today and the posture that I adopted during the ASA conference. Today, I would like to focus on the possibilities that use cogens and use cogens related doctrine, for that matter, provide for addressing environmental crises and challenges that we face. I would like to begin my remarks by looking back to comments that I made in 2019 concerning use cogens and environmental protection. These comments, which I think capture both the promises but also the challenges for environmental law and international environmental law. They were made in my fourth report on use cogens. And in that report, I said the following: by virtue of the importance of the subject matter and the catastrophic consequences that could result from the destruction of the environment, it might seem obvious that norms that aim at protecting the environment, at least some of them, would have the status of use cogens. Yet, there seems to be little evidence of the required acceptance and recognition of the international community of states as a whole that the environmental norms, or some of them, have acquired peremptory status, notwithstanding the empirical fact of the importance of environmental rules for the very survival of humanity and the planet, unquote. So in this statement, there is on the one hand a recognition that empirically norms for environmental protection, at least some norms for environmental protection, should by virtue of their importance, be accorded use cogens status. But on the other hand, the statement suggests that notwithstanding the empirical importance of the norm, the requirements for use cogens status have simply not been met. It is in this context, or it is in the context of this tension, that I wish to share some thoughts on the possibilities for use cogens character of environmental norms. Before trying to assess the possibilities for use cogens, for norms of use cogens uh, in terms of environmental law or some of those environmental norms, it should be asked whether it is even useful to try to identify environmental use cogens. In other words, are there any real benefits to coming to the conclusion that some environmental norms have use cogen status? So let me start with the obvious. And as UN International Law Commission Special Rapporteur on use cogens, this very first benefit is one that I would ordinarily try to downplay, try to hide, but one cannot ignore it. The first benefit is rhetoric. Identifying a norm as having use cogens status is a powerful rhetorical tool which can, by simple virtue of that status, galvanize states and other actors towards action. As an international law purist, of course, this is perhaps the least important reason, but from a purely political and activist perspective, this might even be the most important benefit of use cogens status. But moving on to the more legal reasons or more legal benefits, the characterization of particular norms as use cogens, particular environmental law rules as use cogens, has important implications for conflict of law norms. While this might seem insignificant for domestic law, where hierarchy is well known, for international law, hierarchy and its consequences is nothing short of revolutionary. International law rules in conflict with norms identified as use cogens, including any potential environmental use cogens norms, would be, of course, rendered invalid. Let us take as an example the potential duty to mitigate or prevent climate change. And I should emphasize, by the way, already at this stage, that the purpose of this paper, or rather for the purpose of this paper, the formulation of the potential environmental use cogens norms will necessarily be imprecise, but that formulation is not important, at least not for the purposes of this address. So, but assume that there is a duty to prevent anthropogenic climate change under general international law, however that duty may be formulated, and assume that we all accept that this duty is use cogens. One of the implications is that any rule in conflict with it would be invalid. This would include treaty rules, such as potentially those contained in treaties for large-scale transfer of sources of energy that contribute to anthropogenic climate change. Again, and obviously this will always depend on not only formulation of these cogens norm, but also the content of that norm. So this would apply equally to rules of customary international law. But beyond invalidity, there may be other consequences for the hierarchical superiority of environmental norms deriving from use cogens. For example, it is generally accepted that other norms, not of a use cogens character, would have to be interpreted in such a way as to make them consistent with the use cogens norms. So, other rules of international law would have to be interpreted in a way that they're consistent with environmental norms that are use cogens. In the event that there is a use cogens norm obligation, for example, to prevent anthropogenic climate change, then other rules of international law must be interpreted in such a way as to be consistent with that use cogens norm to protect or to prevent anthropogenic climate change. In a sense, this is almost a sort of an enhanced integration, an enhanced systemic integration rule. So one might argue, for example, that this form of systemic integration is not only to interpret the rule such that it is consistent with use cogens, but in fact to interpret other rules such as to promote or give greatest effect to use cogens norms. A final possible benefit consequence of use cogens status of environmental norms is the fact that use cogens norms produce erga omnes obligations. Now, to take an example, which is different from climate change, I've been using climate change examples too much. If an obligation to protect a particular species of fauna, for example, from harm is use cogens, then a state's failure to act in accordance with such an obligation can be challenged by any state, and not only a state that can show direct harm or direct interest. There are other benefits. I mean, I can think, for example, of the possibility that violations of use cogens norms, including violations of environmental norms that may constitute use cogens, would affect how compensation is arrived at. Perhaps compensation has to be higher if the breach is a breach of Hughes-Cogens norm. The main point, though, that I want to make is that there is real value in identifying some environmental norms as having Hughes-Cogens, and so it is worth, I think, taking the time to identify potential environmental Hughes-Cogens norms and how these could be arrived at. Now, once we have some consensus that there is value in identifying environmental Hughes-Cogens, the question then becomes, how do we identify such environmental Hughes-Cogens norms? How do we come to the conclusion that this or that environmental norm is Hughes-Cogens? I should start by a few preliminary comments. First of all, throughout this keynote address, I have been speaking about environmental Hughes-Cogens. Of course, many of you would have already noted that not only is this formulation imprecise, it may also be unhelpful. The category environmental Hughes-Cogens is useful only if one is able to identify particular norms of Hughes-Cogens: the duty to protect the climate system, the duty to prevent anthropogenic climate change, the duty not to contribute to anthropogenic climate change, the duty to take measures to minimize contribution to, etc., etc., etc. I think you get the idea. Needless to say, I will not in this particular address be able to identify particular norms, let alone show or disprove Hughes-Cogens status for those particular norms. So as a result, my comments are purposely rather broad and general, and are really intended to provide not so much answers, but to stimulate thought, if you like, and to raise questions. Second, it is easy to say, actually, I should say second and more importantly, it is easy to say this or that norm is Hughes-Cogens because it is important to me, right? It is important to whoever happens to be speaking. This statement is true in a general sense. I shouldn't pick on human rights lawyers, but human rights lawyers tend to believe that many, and in fact sometimes all, human rights are Hughes-Cogens. Those that believe in the centrality of states in international law are more likely to make the argument that sovereignty and non-intervention are Hughes-Cogens. Toilers, third world approaches to international law adherence, are likely to argue the sovereign equality is a Hughes-Cogens norm. So this is the my subject is Hughes-Cogens approach. But the my subject, my interest is Hughes-Cogens might actually be equally true for environmental Hughes-Cogens. So what environmental rules are worthy of Hughes-Cogens status? I mean, climate change related rules are obviously easy candidatures, but what about others, right? So subjects beyond climate change. So what about biodiversity? What about oceans, hazardous materials, and so on and so on and so on? I ask this point, I mean, the only reason I make this point at the outset is to caution against the approach that determines Hughes-Cogens status based on the subjective interests of the analyst. So in other words, I myself am strongly opposed to this my subject is Hughes-Cogens approach. But of course, if we don't adopt this approach, if we don't adopt the approach that this is important because I'm speaking, or this is important because it is important to me, then the question remains, how shall we determine whether a particular norm is Hughes-Cogens? It should come as no surprise that the approach that I favor is one that has been adopted by the International Law Commission, and it has been adopted by the International Law Commission on the basis of proposals that I have made. In the interest of time, I will I'll very quickly describe the criteria. Under the ILC's framework, for a norm to be a norm of Hughes-Cogens, it has to meet two criteria. The first criteria is that the norm in question must be a norm of general international law. So this first criteria simply means, in simple terms, that the norm in question must be generally applicable to states independent of any treaty obligations. In other words, for a particular environmental law rule, it would be necessary to show that the norm applies in a general sense to states independent of whether or not it is contained in a treaty. To take, hypothetically as an example, the duty to prevent the pollution of the marine environment. I mean, again, the easiest example, of course, would be climate change related, but let's take the duty to prevent pollution of the marine environment. While this obligation could certainly be founded on several treaty obligations, for this first criteria for use cogens normativity, it would need to be shown that this duty in fact meets the requirements for custom international law, right? I mean, that's what this first requirement or this first criteria essentially means. I certainly think that many environmental law rules meet this first criteria. Of course, based on my experience in the International Law Commission, I can tell you that this view is not shared by everyone based on the debates that we've been having. But personally, I don't think that this first criteria creates problems, at least for the kinds of obligations and the kinds of rules that we're thinking about when we're thinking about use cogens norms. It is really the second criteria that creates the more serious obstacle for use cogens status of environmental norms. And the second criteria is that the norm in question must be one that is accepted and recognized by the international community of states as a whole as one from which no derogation is permitted. This second criteria, by the way, it's even longer than this. It's a norm is recognized, is accepted and recognized by the international community of states as a whole as one from which no derogation is permitted and which can only be modified by a subsequent norm having a similar character. But anyway, this second criteria really is about whether there is evidence that states believe the norm in question to be of a peremptory character. I mean, that's really all that it means. Now, in some of the ILC commentaries, which I must confess to being responsible for, a reference is made to practice in support of this belief. But of course, this is actually incorrect, and I hope to have the opportunity to reformulate this when we adopt the text on second reading in August of next year. It is merely what's required actually is evidence of a belief, and this can be established in a variety of ways, right? So ultimately, what you're looking for is whether or not states believe. And how they express this belief is there are a variety of ways in which this belief can be expressed, but whether or not states believe that norm is a norm of use cogens. Having done a search, a preliminary search, I can say with some confidence, also with some sadness, that there really is no direct evidence for such a belief. That is not to say that I believe that environmental rules are not worthy of use cogens status. It is only to say that there is insufficient evidence of states positively expressing the view that particular environmental norms constitute use cogens. Very often, of course, states do not express views of peremptory character of norms simply because they have not been called upon to do so. Indeed, very often when states have explicitly identified a norm as use cogens, it has been because that norm has been so identified in the literature. The question, which we cannot answer definitively, of course, here is whether, given the chance, or to use the language of international law, if the circumstances called for it, states would in fact express the belief that some environmental law rules had use cogens status. I would venture to say that that is more than likely, but that's probably not sufficient to say. I would venture to say that that is more than likely. The test that I have described, the test developed by the International Law Commission, does not permit this kind of speculation that it is more likely. One possibility may be to rely on the characteristics of use cogens as provided for also in those draft conclusions of the ILC, draft conclusion 4. Draft conclusion 4 describes use cogens norms as those that inter alia reflect and protect the fundamental values of the international community. And interestingly, of the international community, not of the international community of states, but that's a story for another day. I will pause here to note that this language which is ubiquitous in judicial decisions and scholarly writings on use cogens, caused such a stir within the commission when I initially proposed it that one may have thought that I had proposed that the UN Security Council should be disbanded. I mean, that was the vigor with which it was opposed. At any rate, after much debate spanning over 2 years, that language was eventually adopted by the International Law Commission. And so the question that then this raises is it possible then to argue that use cogens norms that environmental norms can be identified as use cogens on the basis of this language? It is certainly very difficult to argue, for example, that the prevention of climate change and the duty of all states to take action to prevent catastrophic anthropogenic climate change does not reflect and or protect the most fundamental of values of the international community. And indeed, there are statements by world leaders that would support the belief that the protection of the climate system is the most fundamental objective of the international community currently. And given the importance of the oceans to sustaining life on Earth, it is equally possible to make such claims about the general duty to protect the marine environment. Yet even here, we are faced with some challenges. First of all, the ILC in its commentaries makes clear that these characteristics cannot replace the criteria. So the criteria are there. I myself might suggest that these characteristics can be used to help the criteria or sort of bolster an argument, but they themselves cannot replace the criteria. Second, even in relation to these criteria, it is not altogether clear that the evidence for the belief that particular environmental norms reflect and protect the fundamental values would be so vast and would be so strong. Again, as with the criteria, I'm sure that if states were polled, in other words, if states were given the opportunity, nearly all states, or at least virtually all states, or a very large majority of states, would identify particular norms, particular environmental norms, or particular norms intended to protect the environment as reflecting and or protecting fundamental values. Yet again, this exercise for identifying use cogens cannot be speculation or conjecture. So where does that leave us? Here I wish to take you back to the words of my fourth report, and I won't quote it again, but those words that identify the importance of the subject matter, and yet the fact that there doesn't seem to be sufficient evidence. I made this statement in part because I had hoped it would be taken up by the ILC in the commentaries to the draft conclusion, and as a result, states would take up the challenge and express their acceptance and recognition of some environmental norms as having peremptory status. The ILC did not, in 2019, adopt that language, and so the quote-unquote low-key call for action remains in the report of the Special Rapporteur, but not in the ILC's work itself. Potentially more damaging to the course of environmental use cogens is the fact that the ILC did not, in 2019, include environmental protection or rules relating to the environment in its non-exhaustive list of use cogens. I know I said I wanted to strike a slightly more positive tone, and you might be thinking, I hope this is not his idea of a positive tone. Well, the ILC's list is rather narrow, and as one very good friend of mine on the commission, Charles Jalo, said, the list, at the time, the list offered by the Special Rapporteur, that would be me, made him feel like we had been trapped in the 1960s, or words to that effect. A silver lining, however, is that the list is not described by the Commission as norms of use cogens, but rather norms of use cogens previously identified by the Commission. Now, this is a silver lining, because by definition it does not seek to describe any and all use cogens norms, but only those that have been previously identified as such by the Commission. Ergo, any norms not previously considered to be on the list, so any list, or rather any norm not previously considered by the Commission would not be on the list, not because the ILC did not consider it to be a norm of use cogens, but simply because it hadn't previously been identified as such by the Commission. Second, the Commission itself states that the list is non-exhaustive and that it is without prejudice to the existence or emergence of other norms. In fact, it states this in different ways in the same paragraph and in the commentaries there too. But these two silver linings are at best underwhelming, I guess you might say. They leave us still relying on conjecture and speculation. They do not provide evidence of Euskoghen's status, only that Euskoghen's status is not impossible, right? And this is hardly a winning argument in court if you say, well, it hasn't been ruled out. I mean, that's the best that you can say. I do think, though, that the exclusion, or better yet, the non-inclusion of environmental norms on the list of the ILC can actually help to galvanize the necessary explicit expression of acceptance and recognition. A statement made by another good friend of mine on the ILC, Nilofer Oral, particularly critical of the non-inclusion of environmental norms on the list, provides some ammunition for those wishing to suggest that the ILC could have done better. Indeed, some states have, in their written comments on the work of the ILC, have already made it clear, or have already started to make such claims. For example, the Federated States of Micronesia made the claim very strongly. So generally the Federated States of Micronesia do not make comment on the work of the ILC, but on this topic they did, and they made a pretty detailed statement. And all of it was focused on this one question of the non-inclusion of environmental norms as part of the statement. Statements such as these from other states would have, I think, a desired effect. And so, in a sense, through the ILC not including the norm in its list, it could in fact galvanize states to more explicitly express their belief that these types of norms, or rather environmental norms, are Euskoghen's. I wish to take a detour, if I may, to note that in the 1970s, 1976, the ILC did come close to what may be seen as a recognition of environmental Euskoghen's. In the very first iteration of the Articles on State Responsibility in 1976, the Commission proposed a draft article on international crimes and international dealings. It was draft Article 19. The second paragraph of draft Article 19 reads as follows. It provides that an internationally wrongful act, and here I quote, which results from the breach by a state of an international obligation so essential for the protection of fundamental interests of the international community that its breach is recognized as a crime by that community as a whole, constitutes an international crime, unquote. Now, the text does not refer to Euskoghen's, but the language protection of fundamental interests of the international community is reminiscent of Euskoghen's language. It's reminiscent of fundamental values that I spoke about earlier, right? The fundamental values of the international community. And it is not a far stretch to assume that the Commission had here in mind Euskoghen's. The norms in question, in other words, the norms in questions are Euskoghen's. In that draft article, in the commentary rather, the Commission recalled that it was clear that there was a distinction between the different internationally wrongful acts based on their importance to the international community. This sounds to me a lot like Euskoghen's talk. At any rate, the third paragraph of draft Article 19 provides examples of such acts, of acts that result from, quote, the breach of a state by an international obligation so essential for the protection of the fundamental interests of the international community that its breach is recognized as a crime, unquote. These examples, number one, include norms that appear on all the typical lists of Euskoghen's norms, such as the prohibition of aggression, the right to self-determination, the prohibition of slavery, genocide, and apartheid. But in addition to these, the following example is provided. Quote, a serious breach of an international obligation of essential importance for the safeguarding and preservation of the human environment, such as those prohibiting massive pollution of the atmosphere or the seas, unquote. So draft Article 19.3d of the ILC draft articles of 76 show that it would be possible to identify environmental use cogens. Unfortunately, reliance on the Articles of State Responsibility as a basis for environmental use cogens is not a particularly strong argument, simply because in the final version of the draft articles adopted in 2001, the Commission did not retain the example contained in Article 19.3d. While it is not so at this time possible to make a convincing argument for environmental use cogens, two things can happen. One, states ought to be encouraged, pressured even, to recognize and accept the use cogen status of some environmental law rules, those that are most fundamental. But also other avenues for heightened normativity of these environmental law rules that could be candidates for use cogens should also be considered. And I would, as I wind down my discussion, wish to point to some of these avenues for enhancing the heightened normativity of environmental law, of particular environmental law norms. First, we have already spoken about one of the consequences of use cogens norms, namely that they produce erga omnes obligations. Yet, as is generally known, not all erga omnes obligations flow from use cogens. In other words, it is not necessary to establish use cogen status of a norm before the obligations flowing from it are regarded as erga omnes. While theories to explain which obligations not flowing from use cogens are erga omnes abound, this remains an important issue of debate. For me, actually, the answer is quite simple. And the answer applies directly to environmental protection, or at least some environmental protection related rules. For me, there are two types of rules that produce erga omnes obligations, and I would say there are only two types. The first is obligations flowing from norms of use cogens, for which the erga omnes character can be explained by the importance of the rule, right? The second category relates to the obligations flowing from rules relating to common spaces, for which the erga omnes character can be explained by the nature of the rules. So the nature of the rule makes it impossible for the rule to have a bilateral character. Now, many environmental law rules concern common spaces, and these rules, whether use cogens or not, can benefit from the heightened normativity that comes from erga omnes character of obligations. Thus, any general rule of international law relating to climate change or the duty to protect the ocean spaces beyond national jurisdiction will, with or without use cogens status, create erga omnes obligations. This is one avenue that can be more aggressively pursued for enhancing environmental protection. A second possibility is less doctrinal and more process-oriented. Maybe the better word to use is strategic rather than process-oriented. States interested in pursuing environmental use cogens could force the discussion through strategic litigation case on climate change. Right? This might be done by pursuing an advisory opinion before the International Court of Justice. The question would, of course, have to be framed appropriately. In particular, it would be too broad, I think, to speak about environmental norms. In other words, it would be necessary to focus, or rather, it would be necessary for any request for an advisory opinion to focus on a particular norm, or at the most, rules relating to a particular norm, or rather rules relating to a particular problem. Second, it would be necessary to frame the question sufficiently clearly to compel the court to answer the question and address the character of the obligation. I would also suggest, beyond the legal question posed, that states would need to make a concerted effort in both their written and oral proceedings to make reference to use cogens character of a particular norm that would be the subject of the request. There are at least two reasons for this. First, this increases, although it does not guarantee, that the court would in fact address the use cogens character of the norm. Second, any such declarations would themselves, independent of whatever the court might say, constitute evidence of acceptance and recognition. On this point, what I will just say is, of course, there have been attempts. Many of you will know of the attempts by a group of states around 1910, around 2010 and 2012, to pursue this matter. In any event, as I conclude, international law provides opportunities for addressing some of the challenges faced by our society. I have elsewhere argued that the ability of international law to make meaningful contribution to some of these challenges is hampered by the inability to shift from a bilateralist model to one which is based on solidarity. Jus cogens is the quintessential solidarity-based doctrine of international law. What better concept there is to drive the protection of the common environment than a concept which has been described in mythical, magical, superheroic, miraculous terms? For reliance on jus cogens, however, still much more work is required. In particular, to avoid the peremptory status is in the eye of the beholder. It is important that states begin to make more explicit their recognition and acceptance of particular environmental norms as having jus cogens status. The truth is, there is no evidence of acceptance and recognition, or at least not enough. Not only because states have not been pushed to, only I think because states have not been pushed to more explicitly declare their recognition and acceptance. And so the challenge that I would like to leave you is that in your scholarship, in your writings, in your engagements, this call for states to more explicitly and more expressly recognize environmental norms as having jus cogens status be made. And I thank you very much.